Hello, I'm Professor Venelia Randall, and what I'm going to be doing is talking about issue spotting. This is the third video in a series on issue spotting. You should review the fir first two videos to be able to put this in context. What we're going to do is look at a specific hypothetical as a way of showing you the issue spotting. So this is adapted from Michael Jacobson's Testing and Grading in Law Schools from 1984. And what you want to do is write down the key facts that lead you to think of a particular crime. Now, you don't need criminal law to have done this. You don't even need to be in law school to to do this. Uh, Generally, the knowledge you have about living in a society will give you enough information to be able to identify a key facts. And key facts are not the facts that lead up to help explaining a crime, but the fact that leads you to believe a particular crime have been committed or made. You may not know the name of the crime, but the fact leads you to believe that it might be something that's illegal. Now, when you talk thinking about torts and contracts, um, civil procedure, key facts are those is the fact that leads you to believe that some tort may have been committed. Key facts are facts that lead you to believe that some contract may have been formed. And it also leads you to believe that that someone can't sue because of a defense to a tort or defense to a contract. Key fact in civil procedure are those facts that lead you to believe that some civil process uh, is necessary. Generally, courses that are heavily grounded in statutes and are uh, regulations require more actual knowledge of the law, which is why we use criminal law for this example, because people have a lot of understanding of what may be a crime in society. So take a minute and read this hypothetical, and I'll read it out loud. Um, Derrick was on the down and out, and in the last poker game, he lost his money, his shoes, and his horse. The only thing he had left was the clothes on his back and his gun. Being desperate, he decided to rob the Dodge City Bank. Strolling barefoot into the bank with his guns drawn, he demanded from Mary Sue, the teller, all the money in her drawer. As she handed him the sack, Jonathan, the half-blind security guard, came out of the back room shooting at whatever moved. Unfortunately, just at that moment, Vera, who was 9 months pregnant, walked through the door. The bullet that was intended for Derrick hit Vera. Vera was mortally wounded and died on the scene. Her unborn fetus dies as well. In the excitement, Derrick, who had never used a gun before, dropped the gun. The gun misfires and bullet hits and kills Mary Sue. Derrick runs out of the bank, and as he gets outside, he realizes that he doesn't have a getaway horse. However, he's relieved to see Star, the horse of his buddy Jack. He knows that Star has a habit of returning to Jack no matter where she is set loose. He gets on Star and rides her out of town, intending to turn her loose once he is a safe distance. As he and Star are sleeping, the posse catches up with Derrick. What crimes has Derrick committed? So on an exam, that may be the only question before you. And the process of issue spotting starts with being able to identify facts that lead you to think that a particular crime has committed, a particular tort has been committed, a particular contract. Um, so let's go from there. So all testable issues fall into a four-level framework. They're either factual issues, theory issues, rule issues, or element issues. Factual issues are facts or occurrences which, under the call of the question, raise a potential legal dispute. And I cannot emphasize that enough. It's under the call of the question. So one of the things you can do to improve your test taking skill is read the call of the question before you read the question. That will make sure that you don't go off on some tangent trying to talk about a tort, trying to talk about contracts, trying to talk about administrative law. Read the call of the question and decide from the call of the question which area of law the test is centered in. So as I said, so you want to isolate each factual situation or occurrence which under the call of the question is legally significant. This is not something you're going to be necessarily good at right this minute because you're just starting. Part of it comes from knowing the law, but another part of it is developing the skill of knowing what is legally significant. And that's a skill that you learn by doing and by processing. There's no list that we can give you to say, okay, use this checklist to learn to develop what's legally significant. No, we can't do that. What we can do is give you hypotheticals and work with you to identify facts and talk about why the facts you identified are or are not legally significant. And then you have to learn to use these as transferable skills. We're not teaching you, this course is not about teaching you torts or contract or whatever substantive law you're in. This course is about teaching you how to write well and pass the baby bar and the bar the first time. So from that hypothetical, let's look at some potential legal facts, key facts. So as you see, we don't have a whole list of facts to be able. Right now, I'm going to focus on 5. The taking of the horse, the holding of the bank, the death of the tailor, the death of Vera, and the death of Vera's baby are all transactional factual issues. Without those factual issues, you would not have anything to talk about. And that's kind of what a key fact sets up a situation where all the other facts become relevant and leads you to a discussion within the call of the question. As you can see, the taking of the horse and the holding up of the bank doesn't require any legal knowledge to be able to pinpoint that. The death of the tailor and the death of Vera, as we will see, will require some knowledge, but not as much as you think. And the death of Vera's baby requires some significant knowledge to be able to pinpoint it as a legal issue. And in fact, the death of Vera's baby can be missed if you don't have the appropriate legal information. And this is important to know for exams. So you start with the key facts, and then what you want to do is highlight them in the exam. Highlight them in the question. So when you're taking the exam, you will go back and you will highlight uh, uh, the key facts that lead you to think that there's something to discuss. So a theory issue then follows the key facts. And the first, legal theory, concept, causes of actions, are defenses. These, when we say theory issues, we are including all of those, not just causes of actions. Consideration, offer, and acceptance are not causes of actions, they're concepts. Uh, Consent is not a cause of action, it's a defense. Cause of action would be something like bitter battery and breach of contract. So, theory issue is when there's more than one theory that could apply to the situation, and you need to discuss which theory applies and why you pick that particular theory. If there's not more than one theory, then you don't have a theory issue. Concept, cause of action, which when you have more than one cause of action that can apply to a fact, and you have to decide which cause of action applies, that's a theory issue. And you have to discuss that. You just don't pick a cause of action and apply it. You explain why the cause of action, uh, you discuss why you pick, what your options are, and why you're discussing the particular cause of actions that you're discussing. So all the same thing goes with defenses. These theory issues are about conflicts in legal theories that can apply to a factual situation, conflicts in legal concepts that could apply to a factual situation, conflict in cause of actions that can apply to a situation, and conflict to defenses that can apply to a situation. If you don't have a good understanding of the law and how it relates to each other, you may end up missing these issues because you will go with the majority, uh, or with just one cause of action. The, in order for all problems have at least one theory, concept, cause of action, or defense. Now, they may not have a theory issue, but you don't have a problem being solved unless you have at least one theory, concept, uh, cause of action, or defense. So let's look at the theory complexity. So with the taking of the horse, so now we're going to go back to the factual issue because that's where everything starts. Factual issue. Well, there are 7 different theft offenses. And so you have to explain that you know that there's 7 different theft offenses and why you are picking the particular theft offenses. And if there are 2 or 3 that are close, then you need to explain why you rule out with the ones that you ruled out. You just don't jump into talking about whether or not it's a theft or larceny. You explain why you decided to talk about larceny. That's an issue and has to be correct, because we use conclusion, rule, analysis uh, as our format. Holding up the brain, there's no theory issue because this is an attempted robbery, and there is no conflicting theories or cause of actions, and so you can go right in. You won't get into a discussion of conflict over theories because there is no theory issue. The death of the teller, also pretty obvious. No theory issue, murder. The death of Vera, now this becomes more challenging because there's felony murder, there's reckless murder, and there's involuntary manslaughter. You may decide to sue on all, you may decide to talk about all or one of those, but you have to explain why you made those choices. Uh, with the death of the Vera's baby, there's actually two theory problems. First, the problem is, can a fetus have a cause of action at all? So you would need to discuss that. Can a fetus have a cause of action? What do the courts say? What do some jurisdictions say? Then you would say, even if you decided that no, a fetus cannot have a cause of action, you would still talk as you would say, but in the jurisdictions that would allow a cause of action, it's still a challenging issue of what cause of action. Is it going to be felony murder, reckless murder, involuntary manslaughter? Remember, at this level, you're not discussing whether or not someone's going to be convicted of felony murder, or whether or not they're going to be convicted of reckless murder, or whether or not they're going to be convicted of involuntary manslaughter. You're discussing which one of these should be applied and why. Okay. Um, Policy reasons, jurisdiction reasons. But so from this five uh, from these five facts, we have one, two, three, four theory issues that have to be discussed. We have to discuss uh, 7 theft offenses and why we picked them. We have to discuss uh, the death of Vera and which kind of murder it's going to apply. And for the death of Vera, we have 2 things we have to discuss: whether there's a cause of action for the fetus, and whether or not there are felony murders, reckless murder, involuntary manslaughter applies. So one of the questions you have to ask yourself is, what are the theories you are learning in the courses you are taking? What are the theories in contracts? What are the theories in torts? Uh, what are the theories in property, criminal law, and how do they uh, relate to each other? So once you have your theory, once you decide on, once you do that, then all theories, cause of action, crimes, or defenses have at least one rule. A rule issue is when there's more than one rule that needs to apply. So the question is, what rule or test or standard must be applied to the controversy? Not how does the rule apply. If there's only one rule, you don't have a rule issue. You need more than one rule to have a rule issue. So let's go back. So we have 7 theft, and let's say we decide we're going to go with larceny as our theft. There's only one rule formulation for larceny, so there's no rule issue. Attempted murder, one rule formulation, no rule issue. Murder, one rule formulation. But if we go with felony murder, there are several formulations of felony murder. On the issue of whether or not killing Vera's baby can have a cause of action, there are several formulations for whether or not a fetus is a person, and there are several formulations for whether or not um, uh, felony murder, if that's what you decided to go with. A rule is when you have majority-minority conflicts. Rule conflicts is when you have alternative rules. Rule conflicts, go back to the previous video where we talk about the kinds of rule conflicts that come up. But this is to show you how so the so all rules have elements, and one of the things you have to do is break a rule down into its elements. When you're first starting out, a lot of uh, uh, the courts will break them down into elements. Um, uh, the alternative readings will break it down into elements. Every cause of action, crime or defense, is made up of a basic set of elements which must be alleged and proved. So an element issue is, are the operative elements satisfied? So let's take a look at the hypothetical. So remember, you're going to do one rule at a time. And this is how come an issue spotting exam gets very complex. So if you decided to do larceny, larceny is the taking or carrying away of personal property known to be another's with the intent to permanently deprive. There's a difference between application and analysis. Application is when there are facts and you just show that the facts meet the rule. There's really no analysis because the facts on their face meets the rule. Analysis is when there are two sides to the story and you could actually argue that uh, based on the facts the that an element is met, and you can also argue that it's not met. So the taking, that's an application, and there's no issue. So there's no issue that he took the horse. Carrying away, that's a legal issue. You'd have to know what the law in the state was to define what carrying away means. You cannot assume that it means picking up, because the courts could have redefined it, statutes could have redefined it, and you would need to figure out what that is. So first you'd have to identify what carrying away means under the law, and then you'd have to do analysis as to whether or not there was a carrying away. Personal property. Again, what constitutes personal property? Is personal property limited things that you use or put on your person, or is it things, or can animals be personal property? That's something you're going to have to know by the law, but you would need to do the analysis and explain that different jurisdictions will have different definition of what personal property is, and that it's potentially possible in some jurisdiction a horse is not a personal property, but in the majority of jurisdictions, horses are included as personal property. That's kind of analysis you would do. Known to be another's. There's nothing, there's no issue here. The facts tell you that he knew the horse belonged to someone else. And so there's nothing to argue here. You can't argue that he didn't know. You can't argue that he thought he could have been wrong. There's nothing in the facts to indicate that he was mistaken in the horse he took. So you wouldn't want to go there. You have to take the facts on the face value with not, you can make assumptions and inferences, but only if the facts that are given allow those assumptions and inferences. And there are no facts that says that there may have been a mistake in terms of the horse that was taken, with the intent of permanently depriving. So this may be a factual issue. If Derrick knew the horse would return, did he have the prerequisite intent? He certainly had to intend to deprive, but this may be more like a trespass to chattel than a conversion, bringing in the kind of torts language, because he clearly did not. He took the horse knowing that it would return and with the intent to let it loose so that it would go back. So, can you argue he had the intent to permanently deprive? And so that's an issue. So, when you talk about element issues, you have 1, 2, 3 elements that you would have to uh, discuss, but you have 1, 2 applications that you would have to say are satisfied, and you would have to tell the reader that they are satisfied and tell them which facts are satisfied. One of the things to remember when you're writing exam, you're not writing to the professor. You're not writing to the judge. You are writing to someone who doesn't understand the law, and you have to tell them everything they need to know in order to understand it. You cannot make assumptions for a lot of reasons. On an exam, obviously, I want to see that you know it all, and if it's missing, I will assume it's missing because you didn't know it. I will not assume that it's missing because you just decided that because there was no issue, you weren't going to talk about it. If you're writing for a judge, if you're writing for the baby bar and the bar, the they're gonna do the same thing on exams. If you don't write about it, you didn't know it. When you're writing for a judge, the reason you don't write as if they know everything for a couple of reasons. One, you may be writing out of the area that the judge knows well. Two, the judge is very busy, and and the more specific you are, the less thinking they have to do. They can just think about whether they agree with what you say or not. They don't have to go back and say, did they miss something? How should this be done? The best way to write is to explain it as if you were going to explain it to someone who was not a lawyer, but in a formalized way. Using your legal terms and using your legal structure. So remember, parties are either fighting over what theory, concept, or defense applies, cause of action applies, what rule of law applies, what standard or test applies, and how the facts are to be interpreted in light of the rule of law, standard, or test that applies. When you see disagreement over the facts, that's generally an opportunity to argue that a particular rule of law, test, or standard does not apply. Okay? In any exam situation, you may have one or more of these issues. In fact, frankly, on an issue spotting exam, you will have all of these kinds of issues, probably in the same essay exam. Here's a flow chart that hopefully, so starting on the call of the question, is there a factual issue? Is there some fact that leads you to believe that there could be a problem under the call of the question? If you say no, then there's no issue. You say yes, then you've got to say, is there more than one conflicting or alternative theory, concept, cause of action, defense that can be argued. Yes, you have a theory issue. Highlight it, write it out, discuss it. No, then it means you had one, because if you've got to have at least one theory, one concept, one cause of action, one defense. So, is there more than one conflicting or alternative rule that can be applied? Yes, you have a rule issue, and you have to explain why that rule applies. This comes up when you have statutes in common law. So under contract, for instance, the UCC and common law are alternative and conflicting rules. And if you're going to say the UCC applies, then you have to explain why the UCC applies in a particular situation. That's not explaining whether that is not at all going into how it will be resolved under the UCC. It's going into why you are choosing the UCC to be applicable in this situation. If there's not more than one conflicting alternative rule, you take your one rule and you break it down into its elements. Every rule has at least one element. Most rules have many. So you ask yourself, are all the elements completely satisfied on the facts? That is, if the fact says that the person had intent, you can't argue intent is not an issue. The facts said that there was intent. If the facts said that the person hit someone and it caused a bruise, there may be a question whether a bruise is evidence of harm, whether a bruise might be offensive. But if the fact says and the hit caused a harmful cut, you can't argue that there was no harmful contact. So then you have what is really near miss issues, and we discussed in the previous. And you on the bar exam, on the baby bar, you will discuss near miss issues, but you're not going to discuss them in the same way you would discuss elements that are at issue. So are all the elements completely satisfied on the facts? No. Is there an element that can never be satisfied on the facts? For instance, the breaking and an entering. So if you looked at breaking and entering and the person went through an open window, then and the state requires that you actually break a window or break down a door, then that element, breaking and entering or entering, can never be satisfied because they went through an open window. Now, if you are a lawyer, you may not raise that cause of action at all because you know that that element can never be satisfied. But on the exam, this is an opportunity for you to show that you know that this cause of action is a losing cause of action because you can never satisfy the breaking and entering. Is From there you take each element and discuss each element, either as an application or analysis. So the only way you're going to learn to do this is to practice. You got to practice hypotheticals. You have to practice essay, uh, find essays online, and just practice identifying the facts. Don't worry about doing all at this stage, depending on this is being made early in the semester from my students. So at this stage, you may not want to worry as much about what theory cause of would apply, but you do want to begin the process of identifying facts that might raise a problem. And you can go back to that exam and relook at it as you learn more law, because that'll give you more practice and help you see how the law helps you identify relevant issues that will need to be discussed. There's just no way around practicing, which means that you have to do more than prepare for class. You have to uh, identify part of your time for preparing for class and part of your time for preparing for exams. And in that preparing for exam part of your time, you need to practice issue spotting and writing. So if you have any questions or comments, post them on Moodle.